21st session of this FDP. And we are having our respected resource person, Dr. Betkar sir, and who is going to deliver a lecture on the topic intellectual property rights and patents, design feeling. So, first of all, I would like to extend a warm welcome to our esteemed speaker, Dr. Betkar sir. Dr. Betkar sir is there?
Yes, yes, yes. I am here, madam. Please continue. Okay. Thank you.
I heartily welcome you,
Yes,
sir.
ma'am.
I
Thank you.
heartily
Thank you.
welcome you,
Thank you.
sir.
Thank you.
But before going further, I would like to give you a brief introduction about our esteemed speaker, Dr. Betkar sir, who is currently working as Principal Shri Kumarswami Mahavidyalaya, Asa, Latur, Maharashtra. He is research supervisor with 30 years of teaching experience and 7 patents are on his name. He has been invited by international conference as keynote speaker at Singapore, Hong Kong, Canada, and UK. Research paper presentations in international conferences at Indonesia and Thailand. He has more than 50 research papers published. He had been awarded gold medal for his research innovation from the state government of Maharashtra under Inter-University Research Festival. He had been awarded Best Principal 2021 by SRTM University. He has been awarded as Best Teacher of the Year 2018 by IASR Institute, Kolkata. He has been invited as a speaker from all our country for more than 200 speeches as expert of intellectual property rights and patents filing also on neck subject. He has published one book on very critical and crucial issue, I think so, on net SSR preparation. He has organized more than 600 international and national events, webinars on women empowerment and women dignity. He has been recorded name in International Book of Records, India Book of Records, and Asia Book of Records. So we are honored, sir, and I take pride to invite you as a resource person on this FDP. So I would like to invite our esteemed speaker, Dr. Betkar, sir. May I request, sir? Over to you, sir.
Thank you, Savarna madam. And today's patron, Dr. Aruna Anchal madam. I am audible. I am audible, madam. I am audible, madam. I am audible. Thank you. Thank you.
Yes, sir. Very
Okay.
clear.
Okay. Honorable patron, Dr. Professor Dr. Aruna Anchal madam, who is Executive Director of Research and Publications Unit ICERT, Dean and Faculty of Education, Baba Mastanath University. The coordinator, Mrs. Mahima, Mrs. Radhika, and Dr. Savarna madam, who just introduced me here. And the next guest of the honor and resource person of session 22, Mr. Sujit Paul sir. First of all, I am thankful to Arunachal madam and all the organizing committee, those who have invited me for this international faculty development program of INMPG College Meerut in association with Indian Council for Education Research and Training, ICERT, USA and India. All the participants, those who are joined here from India and abroad, in our webinar series you have said that about the women empowerment. Aruna Anchal madam was the resource person, so that's why I am happy with connecting with this institute also through this international FDP. And every program of this FDP is organized by all the organizing committee are effective for the aim of this FDP, advancement in pedagogical science and research. It's a 2 week international inter-multidisciplinary faculty development program. I congratulate to this team for taking initiative of this. I would like to share my screen and we will continue to our topic. It's visible, madam? It's visible?
Yes, sir.
Thank you. Thank
Yes,
you.
sir.
Thank you. As we are the from teaching community, we do the research, we publish our research, we try to publish research in journals, international journals, corpus journals. At the same time, we have to give more recognition to our research. There is option, that is the patent. Patent is the superficial research which is higher grade than the publication in any journal. So in the topic today's which I have allotted, that intellectual property rights and patents and design feeling, I would like to share my knowledge on this topic. Those who are here as a teacher, those who have joined here under the faculty development program. Let us see the first objective of our FDP in this session is to know about intellectual property and intellectual property rights. Since patent is one of the intellectual property rights, so first of all we have to know about what the all intellectual properties are available, defined in India especially. And after knowing intellectual property and the rights associated with that, we can go for the patent filing process in India especially. So these are the two objectives of this session. Let us see on the screen. You are seeing on the screen that there is a picture. That picture shows that someone is thinking. And what he is thinking? He is thinking to form an electric bulb. It's the example. Let us see the screen. It stands for I. I means the first letter of the intellectual property rights. Let us know about these words, letters. First I, it is the intellectual thinking of a mind. On screen you are seeing that person is thinking, and he is thinking to form an electric bulb. At this moment, electric bulb is the basic of his thinking, intellectual thinking. He is thinking to form an electric bulb. Now what happens? After thinking, he forms that electric bulb. It is an example. Please understand this. Now what is bulb now? It is an intellectual property came out from the intellectual thinking of a person. It's now the intellectual property. We came here up to intellectual property. Now what happens? If someone not registered the intellectual property on her or on his name or inventor's name, what happens? You are seeing on the screen. Means the persons in from the society can stolen our knowledge, can use our technology, can take benefit of the technology if we not registered on our name. This is wrong one. If someone decided or someone invented something, he should be benefited, and this happens before the registration. Now, so that for getting ownership, for getting rights, intellectual rights associated with that product, innovative product, we have to register it under intellectual property office, IPR office of particular country. Then and then only after registration we get the rights of using that equipment as a owner to enjoy the royalties, to enjoy the ownership, so that the rights given over the creations of mind after registration are known as intellectual property rights. I think it's clear. Intellectual property rights are the property rights associated with that invention after registration through the intellectual property method in the office, intellectual property office. Let us see, there are two types of intellectual properties. One is the intangible, where we cannot touch, like that theme of the book or idea or any music. And second is the tangible property. We can convert intangible property of our thinking, of our innovative idea, to the tangible property. These are the two groups. Now let us go in the next step. What are the intellectual property types? What are the types of the IPRs? Let us see. Let us see, there are 7 types. Let us see first type, it is the trademark. On screen you are seeing that there are so many trademarks I have collected as an example. One is of our Doordarshan Satyam Shivam Sundaram, one is from local newspaper Lokmat, third is Airtel, then WhatsApp logo, and then IBM. What are these? These are the trademarks which we are knowing well. So these trademarks are intellectual properties, because if someone want to start his business or a firm or a product, he or she have to give identity to that product by selecting, by creating a design. There is no ban how to design a banner, how to design a logo, how to design a trademark. This own creation. So in this collection you can see, one is picture, second is the with slogan, that style, all these things, external or with our eye, what we see, that is perfect, and it is registered as a trademark for that product for marketing the goods. Because of this registration, when we purchase a thing, branded thing, from that logo or trademark symbol we can identify that this product is from that company or factory. So this product, this trademark is now used as a intellectual property, because it's now a property they have registered on their name and no one can copy or duplicate it. So intellectual properties, first property is the trademark. Now see the second is the, okay, now it's the example. It was a shop of Bhed, and that name was written on the board with a symbol of TM. Means that this example shows that this name of a particular style of that name is registered under the trademark. This shows many times we can see that one side corner of the R, C, TM. These are the trademarks. They may be copyrighted, they may be registered, or they may be under registration, all these things. Now second intellectual property, the geographical indication. What are geographical indications? Geographical indications are the products, may be man-made, may be natural, but they are famous for in a particular area. The identity of that local area is attached with that, and production of that special product is very much in that area and famous. At that time one can register that special product under the geo tag, that is geographical indications. We are knowing that Guntur chilli, Kanchipuram silk sari, Basmati rice, Kolhapur chappal, Pune pagdi, all these are products have registered under the geographical indications. They have attached the geographical properties of that area and they give the identity of that area from that. So This is also the intellectual property, because when we register that product goes on the international map, and the market economy increases and product also increases of that. So these are the geographical indications, may be man-made or may be the natural one. So Nagpur orange, Basmati rice, Paitan or Paitani, Kullu shal, Nasik Valley wine, Tirupati laddu, all these are words which here we hear that are registered under the geographical indications, and they are the properties, intellectual properties of our India. Now third is the design and utility model. If you see some product externally, its shape, its combination, its design, thickness, external features of that are also registered as a design or utility model. This is third intellectual property. In the picture you are seeing that there are different bottles with different shapes. There is also a plastic chair with different structure. So this is design, external design registered under the design of the intellectual property. And the third is the ornamental wearing women. That example I have given here special, that which are the branded product in the market. They prices their ornaments too much huge, they are so much costly. Why? They have the unique designs, no one can make duplicate of that, and they have the registered their design under the intellectual property, and they are taking benefit of that with amount, with the rate or price of that ornament to a high level. So this is the benefit of the intellectual property with a new design which is registered in the intellectual as an intellectual property. Let us see the fourth intellectual property, that is the plant's breeder right. We are knowing that by using by using the breeder of a new variety of plant, right to use the breeder of the new variety plant, it may be include seed, cutting, tissue, biotechnology. By using these different techniques, if we produce one new plant, that plant comes under the plant's breeder right, and it can give also a intellectual property that is known as plant's breeder right. Now let us go ahead for the copyright. We are all teachers, we are more knowing to this word copyright. What is copyright? It is associated right, universal right with our audio, video, a book, or a painting, or a windows. हां बेट हां एक बोलतो नंतर तासानं. So video program, window software, painting, drawing, rangoli design, a book, all these can be covered under the copyright. One can get the copyright from that. We publish our book, then at that time we have to give a name of to which it is copyrighted is given to woman. So these are the right, this is the right copyright attached with this audio, video, and the design and painting. And the copyright is universal right, because if you have published a book in India, if it is under sale to other countries, you can get copyright. So copyright is a universal right, but other rights are not universal right. They are registered for a particular country in that judicial area. Let us go ahead. I can exclude this story. So we can go ahead to the sixth intellectual property, that is the integrated IC layout designs. As we are knowing that we use equipments which are running our integrated chips, IC chips. They are unique design, they are unique functioning, so that this can be registered under the intellectual property IC design. Now let us see the seventh and important intellectual property, that is the patent, on which we are going to give more emphasis. What is patent then? Patent is a right, monopoly right, granted to a person. It is the right, monopoly right, granted to a person who has invented a new, novel, and useful article. Means if the article is new or novel and useful one, it's different, innovative, at that time our government gives a monopoly right to the person who has invented that thing. Every time it may not be new one, it can be improvement of an existing article. It will also defined as a patent. What is improvement of an existing article? Let us see an example. Uh, Nowadays, our car engine is running on battery, electric car are in market. Before that, engine was running on diesel, then petrol, then CNG. Now hybrid car, engine and fuel and electric car. So these are the modifications or improvement in the same engine of the car. So every time there is no need to innovate new thing, but but innovative improvement in an existing article can be defined as a patent. Thirdly, a new process of making an article. If the article is same, someone have produced that and have applied for the patent, he is granted for the patent. At that time, if the synthesis process, making process of that is different, the process can be defined as a patent or granted as a patent. And more thing is that article should be capable of industrial application. There is no any imaginary thing where patent can be defined. It should be converted into a capable of the industrial application. Now let us see, after definition of the patent, let us see the patent categories. There are three categories mainly patent. One is utility patent, the patent which are more complex, where machinery, programs and all these things are so much complicated or the more innovative, that are frequently granted machines, innovative machines. These are the utility patents, where different machines, complicated machines, where the innovativeness is there, that is the utility patent. Second is the design patent, a product which is special unique design, which is non-functional, applicable, don't have application, don't have to prove its utility. Means on the screen you are seeing that there is a goggle on that lady's eye. It shows a different design. If someone designed a different goggle design, external design, he or she can apply for the design product. Second is the container of our daily use in kitchen product. So someone design may different. So external features of a pot, of a bottle or any useful article, external features, there is no need of functioning utility or servicing all these things. So these are the design product. Third is the patent, plant patent. This is the third type of a sexually produced plants or sexually produced seeds. This can be granted as a patent, as a plant patent, where we use the techniques to produce a sexually produced plants and sexually produced plant seeds. Now, after seeing the types of the patent, let us see patentable inventions, because all inventions are not patentable. So we have to see a list of patentable inventions and non-patentable inventions. Let us see patentable inventions at first. Innovative machines, apparatus or other articles, where the innovative machines which can have innovativeness in that, that can be applied for the patent or other article, those are innovative one. Secondly, process or method of synthesis, a process of production, synthesis of medicines, drugs, all these things, or recipe. This is the process is different, product is same. At that time, patent can be defined. And third, the software which is used with the hardware, that can be patented. The only software is copywritten one, but if it is used to run this that hardware part, then hardware along with that software can be patented. The food recipes of chemicals, medicines are patentable, because when we produce a tablet or a drug or medicine, at that time there are two or more chemicals are used, and when they mix it together, they react, the reaction takes place, and because of reaction, original ingredients lose its property. We get the new product, innovative product. If it is innovative one, then we can apply it for the patent. Now, after seeing the patentable invention, let us see the list of non-patentable invention. It's more important, because if someone decided to file a patent, he did so many study for so many years, and after he found that it is not patentable, then it is useless one. So at that time, we have to see the patentable and non-patentable inventions. Let us say the first, known inventions are not patentable. If I have published a paper or someone have published a paper, that published thing, known thing not be patented. Second, innovations contrary to natural laws. Which are the natural laws are there? If someone is contrary to natural law, producing to prove that natural laws, that inventions cannot be patented. Third, the patent against public ethics and morality. If we lose morality in an innovation that is not useful for us, it cannot be patented. And fourth is the causing commercial exploitation. If the equipment is based on the theme of commercial exploitation, that cannot be granted for the patent. And the products which are harmful to our health of human, animal, plant life or the environment are not granted for the patent, because we are living things, we are doing best for us. If someone is doing innovative thing which can harm to the health of human, health of animal, plant life or the environment, it's not correct one, not good one. So these types of innovations are avoided from the patent filing. Now, discovery of scientific principles cannot be equipped, they are also excluded from the patented things. And substance obtained by admixtures. What is admixtures? Admixtures are just a lemon juice. As an example, if we want to do the juice, we take lemon extract, some sugar, some water, some salt, all these things, which they are mixed together, they give a different taste or flavor, but not reacted in between. There is no innovativeness. One can filter water, one can filter salt, one can filter sugar, one can filter lemon extract, one can filter water from that. These are different, they are not mixed together. So admissions are no innovativeness, they cannot be filed for the patent. At the same time, animals, plants, whole or any part, they cannot be filed for the patent, because this the birth is natural, they are growing naturally. We have no rights to claim the patent on a plant or animal or whole or any part. Now, method of medical cure or horticulture. Method of medical cure means just like a nadi pariksha, just like a massage or physiotherapy, where the equipments are not used, is just for the treatment, medical cure. They cannot be filed for the patent. At the same time, the equipments used in medical field can be filed for the patent. Now, method of agriculture and horticulture cultivations. What distance should be there, how they can be cultivated, this knowledge is not patented, but the equipments used in the agriculture area, they can be patented. Also, we should know that traditional knowledge cannot be patented. That knowledge which is exists from one generation to other generation, they are knowing this product, use of that any product, that cannot be patented. As we are knowing that we are America was filed the patent of haldi, turmeric, then it was revoked by our honorable Mashelkar sir from America, and it is revoked by this, and we get the right of that turmeric patent. So these are the things that where the knowledge is already exist, it cannot be filed for the patent. Now, there is no patent granted on the atomic energy inventions. If someone want to file the patent, he or she have to take the permission from that central government for the permission from the that office, then and then only we get the patent on that. But for this moment, let us see that we can't file the patent on the atomic energy. Let us see few examples. If you see that patent is not so a large and very great thing for everyone, but these are the simple things, but innovative things can be filed for the patent. On screen you are seeing that there is a list, there is a product which is known as anti-itching face mask. What is this? It is anti-itching face mask, and this is granted for the patent. Means it is very simple lock system which is advised by a doctor for a patient not to eat in between. At that time, doctor gives idea, and someone can file the patent on that that is the anti-itching face mask. It's very simple. We can produce this with a simple way. It is just a locking system and the strips are there, so it's very simple. Secondly, patent on back scratching. This we can always feel this this thing that someone can have a machine which can relieve on our patent back scratching, so this is also filed for the patent. Third, there is a patent on medical treatment aimed at curing headache while at the work. So this is the funny patent, because if some officer orders to subordinates to do some work, he always says that my headache, my head is not good, my there is a pain in this one. So at that time, that officer decided to form a pulley, and he filed for the patent and gives treatment to that subordinates so that they relieved, and he got the patent of that. So patent is the need. It can give a burn, it can be used, or it can give the patent can give, need can give the burn to the patent. Now let us see an example. One two ka four, it is the famous song, but now we have used in our patent program. So since on screen you are seeing that there is digital FM tuner. Digital FM tuner is a product from the Philips. It's an example. If we do production of that product, then what we take, what to take care of, how to take care of that, we can file 4 intellectual properties for the single product. The theme, idea, that is the patent. Second, its external features, thickness, switches, display, all these external figure, all these things are registered under the design. The name Philips of that product is registered under the trademark, and the audio or video which you are seeing or the watching, it is also registered under the copyright. So one innovative product can be registered in this way to the 4 intellectual properties. If you produce this digital FM tuner, if you not labeled your product name, then someone can duplicate that and give stick their product's name on that, and he becomes the owner of that. So at that time we lose our innovation, so that one product is related to such 4 identical uh, 4 intellectual properties. Now after knowing the definition of IPR, definition of patent, types of patent, which is patentable inventions, which are patentable inventions, which are non-patentable inventions, by knowing these basic things, we can go towards the filing of the patent or design. Patent and design are nearly same, means patent is more innovative and design is not more innovative, but it's a new one. So we go for the filing of the patent. On the screen you are seeing that it is the first step. Which is first step? Write down the idea as much details as possible, which you have to willing to file a patent on that idea. Means every possibility of that machine, that product, that innovative thing, you have to write so much details. This is the first step. And second is the check for patentability of subject matter. If we do so much exertion and it is not patentable, then we fail. At that time, second process is that we have to take care of the patentability of subject matter. It is patentability of subject matter. If it is patentable, we can go ahead. So it is the second step. Now we are moving towards the filing of the patent. Let us see which forms are used for filing a patent. There are 5 forms are mostly used and compulsory for filing a patent. One is the application for the patent with fee of 1600. Second form, complete specification, there is no fees. Third is the statement undertaking, no fees. Form 9th is the optional one, request for the publication. If we not filed this form, Patent office can give a queue to your patent, and it will be published after 1 year, 1 year, 1.5 year, and the time as per the availability as per the schedule of that office. And fourth, form number 18 is the request for the examination. We have to file application for requesting examination of filed patent with a fee of 2500. It's compulsory one. Application 1, 2, 3, 18 are compulsory, but 9 is not compulsory, but it is needed. We eager to publish our patent, at that time we have to apply for the publication with the fees. Now let us see the form number 1 for the patent filing, and parallelly it will be same as the design filing also. We have to give these details which are on red lines on the form. You can't see so small fonts, but just it is a form, as like we apply for an examination or give to fill our personal information. This red things we have to write one, and lastly we have to put the signature with date and all these things, and we have to apply the controller of patent of that particular area. Second form is the form number 2. It's the complete specification. With the red marks are the points where we can write, and we have to attach the complete patent details, process, characters, diagrams, what you file to patent, that complete it should be attached with this form. Now after these two forms are important, other rest forms are not so important, but we can file it very easily. After that, after seeing the forms, there are three steps again. One is searching, second is the drafting, and third is the sending. Let us see the meaning of these three steps. Searching means what? To search on the available database. When we publish our paper, then we can take reference from the internet resources, library, or any available resources. That is the searching. Similarly, we can search the patents. After searching, second step is drafting, writing of that patent, particular drafting of that patent, and third is the sending. Means we first of think to write something, then we have to search, then we have to draft, then we have to send. These are the before three steps before the filing. Then where to search? Then we have to search the related examples of the patent which are filed similarly to our patent, and we are improving something. So what is difference between your patent and that patent? You have to give the references. At that time we need to go to the search engines. On screen you are seeing that there are 5 search engines which are freely available. That is Google Patent. In simple Google we can search anything as per your requirement, maybe map, maybe images, maybe text, maybe other thing. So Google Patent is the search engine. It gives you the list of patents required for you. Then USPTO is also patent search database of European database. In past, Indian Patent Advanced Search System is also gives a list of patents or helps us to search the related patent. European Patent ESPCO.net and WIPO, World Intellectual Property Organization. If you visit these sites, they can give a list of patents which are published on the same or similar titles, and there are lakhs of patents freely available on this website searching engines. So before filing the patents, we have to search the related patents, because we have to take references from that, and we have to show our differentness, innovativeness, and the innovative things which are different from the existing patent database. Now let us see a simple word PEN. When I written a word PEN on this database, then I get more than 2 lakhs of the patents which are having a word PEN. So such type of database is used for searching the patent before filing. So PEN is the simple thing, but PEN is word is used in many things, many times, at many steps, at many particular places. That may be laser pen, that may be ink pen, that may be ball pen, that may be any pen. So pen is word where we can find it's having more than 2 lakhs times. Second thing is the drafting. Drafting is more important than searching. When we search the patent, you get parallel patents of our patent, like then we have to prove that our patent is how it is different from that, how our design is different from that. At that time we have to draft it in techno legal language, and for that, if we download few patents or designs from internet, if you read few 10 to 20 designs of the patents already granted, you get an idea of drafting. So there is no need to take any help from others. We can do as a teacher selfly that drafting of that patent or designs also. Let us see what is the patent format. Patent format is that just as our research paper, title, field of invention, background of invention, it's the prior art, object of the invention, what is your object, what is the statement. In the one or two lines you can give the statement of that. Then summary, we have to attach summary, what your actually innovation is, on which base it is applied, what is the main theme of that is the summary, and then brief description of the accompanying designs, which designs you are used there, which graphs you have attached, which type of innovation you did, you have to give a brief description of that. Then detailed description of the references to the drawing examples, we have to write an abstract similar to our research paper. We can find the format for the patent is same, but we have to write it very carefully and very particularly. After searching, after drafting, our third step is sending. Where is send? How to send? There are two types of sending again. One is the manual sending and second is the e-sending. It's very simple that in manual sending we have to download the app forms, we have to print, type the forms, and then we have to send by post or courier. This is the first thing. And second is the e-sending. If you visit ip.india.government.in website, there is a way, there is also the opportunity to send by e, which without going from home away, we can send the patents through ip.india.online.government.in patent filing. You can use this website, you can file your patent through your home, or any design you can file to the patent office. Now where to submit? If you are sending by e or by post office, then we can mention our area. There are 4 offices which are in some judicial areas for the particular region: Mumbai, Chennai, New Delhi and Kolkata. Where our residential addresses from that area, we can apply the patent for that office. There is first of all, I want to know you that there is no difference between filing the patents in any office, because all office just collecting centers and they process patent in one office, that is the main office. So there is no any botheration about where to send. So types of patent filing application, up till now we have seen that which forms are required for the patent filing or design filing, where we have to send. And now see what are the types of patent filing. There are 2 types of patent filing. There is no provision in the design filing, there is no design, we have to file completely. Let us see the difference. Provisional filing means what? Just the form number 1, just you write the summary or the abstract of your work. Form number 1, just a fee of 1600 and title registration with some abstract. That is the provisional filing one. Today you can register a patent title on your name with provisional filing. That's all. This is the provisional filing. But after provisional filing, after registration of the title, we can file the complete patent within 1 year. As per my knowledge, that time may be different, but at this moment I know that it's 1 year. Within 1 year we can file the complete application with form number 1, form number 2, form number 9, form number 18. So all these forms, fees, and the details, drafts and drawing and design sketches, everything you have to draft it and attach it, because it goes then and then only for the examination. Otherwise provisional applications are not you go toward the examination, because there is no matter what is should be there should be checked or examined. So complete specification is the must for granting a patent. There is no need to file provisional patent. If you decided that we can file direct completely, then you can go to file for the complete specification. But few times our we have to make our mind to file a patent. At that time we can start a beginning by filing provisional patent through a title. That is the importance of that provisional filing. And once we provisionally file that, we get some responsibility of that to complete within 1 year, not to lose that title. Huh. Now the process of grant. There is grant process may 3 to 5 years may cover. That is the filing application. After filing, patent office publish the patent application. It may be early or it may be regular. Early publication means with fees, and regular publication means without fee. Then fees. Then you have to wait for FER, first examination report. And when your patent is published, when it is examined, then they give a letter to you, they issue a letter to you, patent office. That is the first examination report. They find, if they find some queries, we have to reply for FER, we have to respond it within that particular time duration which they have mentioned. And if the patent office is satisfied with that, that gives the decision, it may be patented or not. At few times, if they are not clarified everything, they can invite you to visit the office for discussion on that particular point. So that process is available, but FER is sufficient to give the answer of that. Now let us see about the rights of the patents. As we are knowing that patents are territorial rights. If you file a patent for a country, for suppose in India, we can enjoy the right in India only, and the rights are applicable in that country where we have filed, not out of that country. If you want to file the patent, take enjoy the benefits from other countries, you can file the patent for that particular country. Now international phase of application, PCT, in patent corporation tactic is such that for the single application we can take benefit of more than 150 countries by a single application if you file the patent application through PCT. So this is the benefit, because the India have given some memorandum or some assignment to other countries for filing the patent. After filing PCT, we can file the national phase application. But if you want to file the patent out of India, then you have to take permission for that. After that, you can also file the patent in the India also for international within a particular time, within I think within 6 months in the after publication to the foreign office, abroad office, we can file to India also. Now let us see the next part. Who can submit the patent application? Who can submit patent application? Patent application can be submitted by himself or herself, or known as the first or true investigator can submit the application in the patent office as the applicant. Secondly, applications can be filed jointly. Means if someone is working with his or her research supervisor and they have invented new formula or new equipment, they can file the patent jointly on research supervisor and the research scholars on research scholar name. At the same time, if an institution have granted some amount as a fund. At that time we have to also acknowledge the patent jointly with that institute also. If don't want to go to the office, you can file your patent through assignee also, giving a letter to your assignee. You can send your patent to the patent office, or through an authorized IPR agent. If you are not knowing the idea of searching, idea of drafting, or you are not knowing the particular things how to file the patent, then you can take benefit of the facility through an IPR authorized IPR agent. The IPR agents are passed the exam of the patent office, and they licensed to guide those who are needy or willing to file a patent. So by paying the fees of that particular IPR agent, we can file our patent. So for filing a patent, there is no need of qualification, there is no any age limit, there is no any language you must know anything. If you are illiterate but you are having innovative idea in your mind, you can approach to IPR at the IPR agent. You submit your orally your idea to that person. He or she can convert your patent draft words into the patent and can file the patent. So patent filing, design registration, or IPR ownership is not the subject of the teachers only. They can be filed by the teachers, they can file the non-teaching staff also, they can be filed the student, they can be filed the teacher, they can file the illiterate persons also. Anyone can file IPR. Now lastly, if unfortunately someone is dead before filing the patent, then the legal representative of that person can file the patent on that person through the office. Let us see the tenure of the patents. You are knowing that if patent is granted to a particular person, he or she cannot be enjoy the benefits throughout the life, but there is a limit. And let us see under this section what are the tenures of a granted patent. Patent can be enjoyed for 20 years, copyright 70 years or up to the living of that owner, designs for 15 years, plants breeder rights for 15 years, 10 years for the geotag, and trademark 10 years. But geotag, GI and trademarks can be renewed after every 10 years, but patent, copyright and designs cannot be renewed. That's why only the companies which are running from last 200 years, 300 years in the world, they are still using their same trademark because they are renewing after 10 years, 10 years, 10 years. So this is the tenure of a intellectual property. Now you might be having question in mind that what can do with our IPR. What is IPR? IPR is just a certificate given by Government of India as a grant patent certificate. Then it's only the certificate. What can we do with that? We can do assignment of the IPR. Intellectual property means the same property as like our physical property. Which rules are applicable for the physical property, the same rules can be applied for the intellectual property certificate. If someone is having in financial crisis, he or she can assign property for particular duration by borrowing some money and to solve the financial problem. Same thing, if you are a patent holder or any intellectual property holder, you can assign your intellectual property for the needy person for solving your financial crashes for particular clashes for particular period, and then IPRs can be sold. If you are owner of intellectual property, you can sold the property as a owner. Intellectual property can be sold, and after selling you lose the rights on that, and the person which purchases as like our physical property can enjoy the benefit of that intellectual property or the patent. Similarly, Intellectual property can be gifted also. You can file a patent. If you grant a patent, you can gift your patent to your friend, and at that time who receives the patent, he or she can enjoy the benefits of the patent but not the inventor from that agreement. So as like a physical property, intellectual property can be assigned, can be gifted, and can be sold. Now let us see the second part, that is infringement. What is infringement? As like in physical encroachment, there is infringement in the intellectual properties. That is unauthorized use of a product, duplication of the product, or sale of duplicate materials. All comes under infringement. It's a crime, and it can be, this cannot be adopted by anyone, and it is the also danger to us also. Since on screen you are seeing three products: OK, Ole, Bilseri, Bisleri, Colgate, Colgate. These are look similar, but one is original, one is duplicate. So this is the infringement in the intellectual properties. If someone is doing that, it is crime and it is fine and punishable thing. So that this is the wrong thing. For an example, Samsung have filed, means Samsung have Apple company have covered any more than $1 billion fine from the Samsung because of the copy written software of that Apple. Samsung was used without the permission, and they have introduced the brand in the market. Now let us see few news. Researchers and students of the IIT Madras have filed in 2020 more than 184 patents in 2020, because 2020 was the period of the corona. At that time, that research students, teachers, and faculties have filed more than 184 patents in that field, in that area, and out of which 9 patents were related to COVID. What are the patents then? We are using for sterilizing machine, we were using for the cleaning machines in that time, that are granted for the patents, and they have filed the patent on COVID machineries. But there was no patent granted for the corona drug from all over the world. That disease so arise that no one can benefit of that drug, means medicine on the corona. So all the medical associations of the all the world have banned to file a patent or to grant a patent on the corona drug. Let us see what are the benefits of IPR. From last 1 hour you are listening the benefits of IPR. What are the benefits? IPR means design, patent or design. Patent is having some superficial complex nature. Design is not so high quality patent, but the new innovative design which can be used by the market very easily, and improved design can filed as the intellectual property. Let us see what are the benefits. Protection of innovation is the first benefit. Means if you have do some innovative thing, it should be registered on your name for getting the benefits, and that protection is given by the patent office to your patent, to your design, to your intellectual property. That the first benefit of protection of your innovation is the first benefit of filing the patent or intellectual property. Second, transformation of your own basic research into new products. When we see the market strategy, you try to purchase more and more refined product or more and more super product. Is the benefit of the patent. If those products are registered, if those products are innovative one, they can be filed and they give boost to the your research to convert your research into basic research into innovative products. Now, author of the IPR or the institute have gained the reputation. If you are patent holder, or if your institute is having some patents with you, then definitely your reputation of your institute goes high. This is the good thing. Also, IPR attracts potential uh, buyers. Means uh, if you have intellectual property with you, if some group is willing to do that product on that machine, so at that time what happens, they approach you for a royalty as your own rate to commercialize that product. So IPR attracts the potential buyers. If you have that IPR with you, those who are industrialists, they can approach you to commercialize your product into the marketing. Now, ranking improvement. If you file more and more patents from our institute, definitely the ranking of that institute goes high. This is the benefit of the patent or design filing. Now, at last, we see that there are there was advertised in I think 85-86, in the time of 85-86 of Hero Honda brand. Fill it, shut it, and forget it. Don't forget it. Means at that time there was so many bikes available, but other bikes having the average of only 15, 18, 20 kilometers per liter of a petrol or that fuel. At that time, the Hero Honda introduced its more innovative engine in the market, which is having efficiency of 85 kilometers per liter. So that is innovativeness converted the advertise, fill it, shut it, and forget it. Similarly, the teachers, the research scholars, or anyone joined here or may not be joined here, they think about their innovativeness. If they want to publish a paper, they publish a paper. They search innovativeness in that. If you file it, you think it for innovativeness, what is hidden in that, you find it, and then you draft it as a patent or as a design through that. And don't forget to file a patent or to register a design through that. This is my message to all. Think your innovation, draft it as a patent or design, and don't forget to file your intellectual property and patent. Thank you to all. I will acknowledge that all the images, videos, information in this PPT are taken from the available resources. I am thankful to the all the resource holders who are the owners of that. I have used it for the educational purpose. Thank you to all. If you have any problem, we can discuss.
Thank you so much, sir, for this very informative, interesting, and wonderful presentation. And I think now the floor is open to all the participants. If any participant has any query or question regarding the topic, he or she can ask. And if anyone wants to discuss or put his or her views over the topic, so the floor is open. You are welcomed to speak.
Good evening.
Yes, yes.
Okay, thank you, sir, for your excellent presentation and visualization and well-explained slides. These patent rights are in business world, they are intangible assets. That means ownership represented by piece of paper. So once you have creating a new idea that did not exist before, so the government of India, India or any other government countries that issue the right to use that. So that's called in short patent. So if you have a patent right and also commercialize, now business organizations, they calculate the amortization for that. One is since it is an asset, because it's represent in the balance sheet, income statement, and the like. So that balance sheet or financial statement clearly represent what the firm's overall performance. So investors and any other, sorry for my sound, will be invest or don't invest. Their decision is based on that financial statement.
Yes.
Now, sir, I have one question here. Once you are commercialized that patent, so
What?
the business wants to calculate amortization. But after purchasing that right from the original patented person, can that organization may reproduce and also invent new things? Does it a patent or not?
Yes,
Can get the organization by itself?
if someone purchased a patent and started commercialize it from that, if they feel that technology is more ahead nowadays, if they improve something in that, because they are already purchased their patent and they are already marketing or branding that product in the market, they are doing their business. At that time, by taking feedback from the customers, they can improve that equipment, they can improve that IPR, and they can file their own patent on the improved that IPR part. In the definition of the patent, I myself said that there is no need to innovate new thing every time, but if you add some improved thing, innovative thing in already exist models, that can be filed for the patent, and after that they get the ownership, means those who have filed for that after purchasing a patent, they can file their own patent on improved of that. I think it's your answer of this your question, sir.
I didn't get, sir.
Didn't get?
Yes, yes, yes.
Thank you, thank you. Very nice question, because first of all we can purchase a thing as a patent, and then if you take collection feedback from the customers and they said that these are having thing this drawback, you can improve that thing, file the new patent on that, and you get the owner of that also, new patent. Okay, thank you for nice question.
Sir, my question to you is that how we can obtain more benefits from the commercialization of the patent, sir.
Thank you, Jyoti madam. Since if you do an innovation and filed a patent, if it is circulating in the market in more ways, you are not product design, you are not doing marketing, but someone purchasing your product, that patent, and commercializing that, he or she or that organization first calculates what the benefit of from that, how it will be reached towards the in its domestic or in official or anything. So use of that, getting benefits from that, we have to decide, they have to decide which rate it can be purchased as a royalty, because we have no factory, we cannot make the product. But if suppose that if there is a product which can approach to every school, because myself I have designed a patent which is to note the reading of very small things, diameter of like thread or very less than thread. If that equipment is approachable, useful to all schools, if any company or those who are doing the market of that schools, if they approach you that every school can purchase this, they calculate the benefit from that, and you can increase royalty from that. So patent is not having the particular price, but the purchaser design so thinks that how product it gets commercialized, how it get benefit, how much, then they can give more and more royalty to you. That's depend upon. Or in R&D, if we do some research of chemicals which are a very huge amount of price high rates, if we do expenditure on that, then we benefit, we should think that this should be minimum this cost, because we have already done the research of 5 lakhs from that, So we can get 20-25 lakhs as a royalty, you can expect it. So there is no price of any patent, you can't decide, but the needy person can decide that how it will be circulated in daily home, as a home product or school product or official product. They can give the royalty to you depending upon that only. Thank you.
Thank you, sir. My second question to you is that how we can come to know that our for our patent we are having national value, more value in national level market or international level market. How we have to make the judgment, sir?
Huh. What the need of the nation, what the need of the public, if you have to take in your thing for that, and if you do some innovation in that, and if you file patent or design the same thing, then it goes to international and national level also. Use of that product is important. Suppose my student have filed a patent on rocket fuel. So rocket fuel is the not the problem of domestic or school or any office, but is the product of nation. Because for launching the rocket, what the fuel are using, the fuel is the national international level thing. So which things you are thinking on that, it may be circulated on national or international level, that gives the level of that your goods or product or innovation. It may be international or national, where it is used in laboratory, in other laboratory, or domestic use, or in only in state use. That's depend upon that. And if you, once you publish your patent, there is special organization having special R&D section. They always search the patent database, which is published a patent, can we commercialize it, can we do the product for that, and they approach to you. Because there is special, they have did a section for searching new patent daily. And so that they approach you, sir or madam, you have published your patent, we want to commercialize it, what the royalty you expect from that. So this is the separate section of searching the patent. They always search to you your patent, don't worry.
For patent, we are certain undergone some international standards, sir.
Patent can be filed through India and on international level also. If you file patent through the India, for the India only, it is a national patent. And if you file the patent out of India, then it also international patent we define for that. There are two ways
Okay,
for,
sir. Thank you. Thank you very
there are
much.
two ways for filing the patent. Many researcher can file first patent out of other country other than India, where their work is more recognized and they have easily patented, and after that they file to the India also. So international and national filing is there. Thank you.
Sir, one more question.
Yes.
Yes, you can proceed.
Okay. To obtain a patent, it's an invention, and so you should have to be meet certain criteria. Basically, the criteria differ nation to nation, but mostly the novelty criteria. That means the invention must be new and not publicly disclosed. The other one is inventive step or non-obviousness. The invention must be involved in inventive step, meaning it should not be an obvious improvement. Industrial applicability, enablement, and also utility. But that industrial applicability for all patents is mandatory.
Applicability, as you have said that there must be innovativeness, all these things, new one, novelty one, not published, all these criteria. Applicability is also important, because if you don't define that product where it is used, then what is use of that explanation that product. So that applicability means somewhere, maybe in school or industry or the domestic, anywhere it can be modified or used or applicable. What is the use of imaginary things? So that's why applicability means, if someone want to produce some article from that, that should be designed one. That is the more important one. If no application are there, there is no use of them thinking, filing, all these things. So applications are important for that only. One can design the patent, one can file the design for the application in search for the application. Someone maybe from aircraft to maybe from our kitchen, anywhere it should be applicable. That's why only it gives the boost to the thinking to the person to market that product. That is the innovation. Applicability is for that only, because without application we can't do anything as a seriousness or can file patent. Okay, sir.
Yes, I definitely got it.
Any other participant?
Thank you, sir, for your presentation. Can you please explain the difference between patent and DOI?
Patent and, please repeat, patent and.
Yeah, can you please explain the difference between DOI and patent?
DOI, what is the long form of that? If I get long form, then I can explain. DOI.
DOI, when you write a paper, you publish a paper,
Okay.
there's, yeah.
No. Patent is innovation that is granted for any by any government. That is the patent. DOI means just indexing, document indexing in that particular research. Your document indexing is the DOI. Any paper, it may be having potential of filing patent or not. If it is too much standard of that patent publication can accept it and allows your DOI. It's an indexing number, and if it is a patent, then its indexing can be done by the government of India, that patent office. Okay. DOI is the just indexing of that paper, research journal paper. Okay.
Thank you.
Okay. Thank you. Welcome.
Any other participant? So before expressing my gratitude to our esteemed speaker, I would like to invite Professor Aruna Achalman to say a few words over the presentation or the session.
Excuse me, ma'am. I have a question.
Yes, of course.
Good evening, ma'am. Good evening, sir.
Good evening.
Recently, what happened? There was a district level competition for dance, and what happened? One of the participants, they used a song. Actually, as it happens in general, ki whatever we find good, we use it. So when the presentation was going on, means one person came and he said, "This is his song and this is his personal. Nobody could have used it without my permission." So generally it happens with general public. They don't get to know whether this is personal property or it's not. So how can the common people get to know about it?
Thank you. Because which matter is published, maybe your newspaper article, maybe your poem, maybe your any book, or maybe any that type of drama, picture, all these things, they are published and they get the copyright. When they are published, naturally they get the copyright. But if you are using some song of others or any resources, you have to take permission of that, acknowledge of that, then and then only you can use that, because otherwise from next day it seems to be yours, those who are listener first time. So it doesn't happen, it does not happen, but so that in audio or video CD you see that copyright is to this company, to this brand, T series, Venus, all these things. Why they have written that? By taking this any part of that, there is strictly written that using any part of any type of this is prohibited, and you have to take first written permission from that author, then and then only you can use. They give the your authority free, or they can charge the rate, but everything is copywritten. But at the time, few persons said that it is royalty free. You can search royalty free pictures, royalty free videos, royalty free images on that Google. So at that time there is no one is coming ad for banning. But when there are famous songs, famous themes, famous, and someone using for commercial purpose, maybe education purpose it may be excluded, but for commercial purpose they can ban you, so that you have to take permission from that writer, poet or director. So that you are knowing that before few years there was a Janjir picture of Amitabh Bachchan. It was broadcasted by a Mumbai channel. So that Mehra's third generation or son of that Mehra, he have put the case on that, because without our permission we have broadcasting rights of that, and you have did public broadcasting of that from your channel without permission. So the case was approached to the court, and he got the royal that fine to that. There are so many cases. Amitabh picture Zund, you was knowing that that was also banned for few months, because that story was of that person, and they have used that picture without that permission. There are so many cases where we cannot use the anyone's creation without the permission. One thing you are knowing that there was a dress designer of a heroine of Delhi, and he have agreed that she have agreed with that director, dress designer. This dress is used only that picture only, but unfortunately she have used that weird that dress in other public show. Then he put the case on her, copyright ban on that to that lady. Why? Because that was banned, copywritten was there, it was written matter that it is used only in that particular picture only, not for other. After that she have used it, and he put the case. So this is the matter of taking benefit of any using any audio or video or any, you have to find out the author, and you have to return that communication, take permission if there is copywritten. And if you royalty free, you can check and use that audio. So that's why when our TV shows they use the famous song, at that time broadcasting, they exclude that, cut that scene of song, because it may arise the question of copywritten also. That's why. Thank you.
Thank you so much, sir. There are two questions in the chat box. Can I read on behalf of you?
Yes.
When we do several research articles and publish it, have new findings, is that patent?
My last slide was that if you publish the research paper, before publishing you have to think if there is a potential of filing intellectual property rights like the patent. If there is a potential, you get some idea, it's innovative one, and we can file it. So before publishing you have to file it. So if you think innovatively through your research, then you can find the idea of design or patent in that, and then only you go for filing the patent before publication. But unfortunately you have published that paper, someone may file who is expert from that, अरे ये तो बहुत ही अच्छा है, इसमें पेटेंट हो सकता है, इन्हें तो ऐसे ही पब्लिश कर दिया, तो मैं इसके ऊपर पेटेंट क्यों नहीं लिखूँ. और once he have filed the patent, you can't do that, and you have to prove that within 6 months there is margin to publish you. सो हमारे पास अगर कोई अपना रिसर्च है तो उसको पेटेंटेबल है ऐसे लगता है, आपने अच्छा रिसर्च किया है, तो पेटेंट बेस सर्च करके इसके जैसे पेटेंट कोई है, अरे अपना तो इससे बेहतर है, तो हम उसको पेटेंट में बदलाव कर सकते हैं. ओके.
Have you got it, sir? And another question is that how can we now patent education related or humanity related course? It seems science oriented courses are directly beneficial of this largest.
Please read.
Have you got it, sir?
Please read.
How can we now patent education related or humanity related course? It seems science oriented courses are directly beneficial of this largely.
Since courses, softwares, all these things are not patented, they are copywritten one. First thing, if the equipment is having potential, means if you design a equipment which is used for the marketing, maybe school, maybe anywhere, then and then only you can file the patent through equipment. If you are having courses, if you have written material, if you are having your audios, videos, they all are copywritten. They can be applied for the copyright but not the patent. Okay, if there is equipment from that literature, you can file separately for the patent. It may be useful for education, may be useful for kitchen, may be useful for a garden, may be useful for office, may be useful anywhere. There should be equipment, then only patent. If there is only literature, theory, only design, it can be applied for only design, external design, or as a copywritten.
I think you have got it, sir. And there is another question. When we take so many references in our footnotes, then how could we prove novelty for getting patents on our article?
Yes, if you are thinking of file a patent, you have to search more related patents available on the patent dash search engines. As I have said, you get so many patents, but which is most related to it, you can take benefit of that. You can refer to 3 4 10 patents, however it's different, however it's innovativeness, then and then only you can prove that the existing equipment is like this, we have improved like this, its innovativeness like this, and its benefit like this. If you prove that, that will be the new patent for you. So you can, so that you have to search on patent search engine, then and then only you can say that it's new, innovative, and not found anywhere. That's why search engine, so patent agent file means they help you for searching, but they charge very huge to you, because there is search engine. We have to refine search, then we get the patent like this. As in example, I have said that one pen word was there. Pen is lakhs times we can use, means for laser pen, ball pen, ink pen, inkjet pen, pen word where if you use, they can use all patent, 2 lakhs patent, but you do unable to search that. So you have to do specific research, refined research, and then you get the same or similar innovation as like your patent. You have to really give the relation of that, how your is improved. So that is the method of searching is more important, because you have to say that our is different, innovative one. Okay.
Thank you so much, sir. And this is really nice to hear you for this descriptive or informative or so well defined presentation. And you have very well defined each and everything regarding IPR and patents filing. Suppose you have very well defined first the two groups of IPR: tangible property, intangible property, and types, trademark, geographical indication, design utility model, plant breeders' right, copyright, semiconductor IC layout design, and patents, and the categories of patent: utility patent, design patent, plant patent, and patentable invention, non-patentable inventions, and types of forms, and the 3 steps of filing patents: searching, drafting, sending, types of patent filing, about types of patents. You have discussed so many aspects regarding IPR, and you have, I think, very well expressed each and every thing regarding this. So I think the participants will be satisfied and will be got benefited this session. So thank you so much, sir. And we have honored to have such a resource person in our FDPs. Thank you so much, sir. So this was really, I extend a warm gratitude to you, sir, on behalf of ICRT team and INMPG College, Meerut, sir. Thank you so much, sir.
I am thankful to all of you, madam, Arunanchal madam, to you, organizing committee member, or the coordinates and the college authorities for giving me this opportunity to link my knowledge, to share my knowledge on this platform used for the teachers for their development, faculty development program. Thank you, madam. Thank you to all.
Yes, sir. It's our pleasure, sir. Thank you so much. So, dear participants, let's move to the next session of this activity. So, welcome back to the 22nd session of this FTP on the same topic. And we are having our esteemed speaker, Mr. Sujit Paul from Delhi. And the topic of this session will be same. So I would like to extend a warm welcome to all of you, especially